Now let's discuss the legacy of Supreme Court Justice Ruth Bader Ginsburg. Of course, the cases she tried, the barriers that she broke, and her role in landmark decisions. Justice Ginsburg left an enduring mark on America's legal history as a leading voice on cases ranging from abortion rights to equal pay. Bloomberg's Scarlet is standing by with a special guest to honor Justice Ginsburg's contributions.
Thank you so much, Caroline. In today's Bloomberg Equality, our ongoing conversation about the bottom line impact of diversity, I want to welcome University of Virginia Provost Liz Magill. Liz served as a clerk to Justice Ginsburg. Liz, thank you for joining us. And first of all, my condolences to you. I understand that you clerked for Justice Ginsburg from 1996 to 1997, which was about 3 years into her term, so fairly early into her term. What surprised you the most about working for her?
I'm really happy to be here, and thanks for the condolences. What surprised me the most? It was the work ethic that she exhibited, and everyone in the office exhibited as well. We worked very closely together all the time, and she was no exception to that rule.
For 3 years, Justice Ginsburg was the only woman on the Supreme Court after Sandra Day O'Connor retired, and she once described those 3 years as the worst times. Talk a little bit about how important it was for the male justices and the male attorneys who argued their cases before the court to see at least 2 female justices rather than one token woman.
That's an excellent question. I'm not sure I'd agree that either Justice O'Connor or Justice Ginsburg, when they were solo on the court, were token women, given their considerable accomplishments and their contribution to the court. I do think a litigator in the courtroom looking up at a bench with 2 or 3 or more women or people of color, it looks like a different court, and probably to the country as well, it looks like a different court. Internally, I think Justice O'Connor and Justice Ginsburg had a relationship born out of being the first in many different places that they had been in their professional lives.
Yeah, pioneers for so many different reasons. Now, Supreme Court justices are obviously fully formed jurists by the time they make it to the high court. Do you recall any examples of how Justice Ginsburg perhaps swayed or influenced her peers' thinking on the court, even as they had these fully formed opinions? She must have swayed them in some way or form.
Well, I think they have fairly fully formed general views. I'm not sure it's the case that they have fully formed views as the case gets much more specific on to a particular set of facts, a particular statute. The way persuasion worked at the court when I was there, and I think for most of its history, is actually persuasion by the power of the argument and what's in writing. One of Justice Ginsburg's favorite phrases was, "We'll see how it writes." So it's a quite different experience than the legislature. I worked in the U.S. Senate for a couple of years before I became a lawyer, and it's a solitary kind of persuasion where you circulate a 20-page opinion with 6 reasons in it. I have no doubt at all that she swayed her colleagues, both by the model of a human being that she was as a litigator and a very accomplished attorney and jurist, and also by the individual arguments that she made. I think she changed some justices' views on issues like the Virginia Military Institute case, but I can't be sure what the specific cause and effect is.
Right. I mean, at this point, we can kind of only look back and wonder. I love that phrase, "we'll see how it writes." Some of her obituaries note that her victories on the court were few, and that she did her most memorable work in dissent. Now, from what you saw, did she approach writing dissenting opinions differently than writing majority opinions?
Well, I think if Justice Ginsburg was alive today, she would take issue with her victories were few. She felt very strongly about the procedural aspects of federal law, and some of her most significant opinions to her would have been some cases in civil procedure and federal courts, so that don't attract headlines, but were very important to her. She did approach a majority opinion differently than a dissent, and I think the critical aspect of the way she thought about it was she was meticulous in trying to understand the views of all of the justices she was writing for. If she received an assignment to write a majority opinion or a dissenting opinion. She was very careful to keep the group who had voted to be on that side, either the majority or the dissent. And then I think in dissents, this is something she said in public at Stanford when she gave a talk out there when I was the dean of the law school. She thought of some of her dissents as for history, and that she hoped that some of those dissents would eventually become majority opinion. So she was writing not just to the court and the public at that time, and the readers of those opinions, but maybe 20 or 30 years hence, when a dissenting opinion might become a majority opinion.